Yes, right?
To an extent. I mean,
To an extent. Well, for what
when I had the time, I didn't have any money. I mean, I
does
could.
it cost money to go to AA?
Well, no, it costs money to put gas in my car.
Did I tell you? Give me a break. Did I tell you to call the court and go on Zoom with me if you didn't have the money to pay?
So
You
then,
had the money to use drugs. Drew Gerald Jr, 26B, 1502441A and B. Mr. Gerald, your name?
Drew Gerald?
I placed you on probation under section 7411 on May the 7th of 26 on a drug case. I also placed you on probation on that same date for operating while impaired. And I here now have in front of me a violation of probation. Yeah, I think Mr. Teal's on that one. I have a violation of probation that alleges that you on count one failed to pay your fines and costs as ordered, the rate of 75 per week. Count two, that you failed to refrain from consuming alcohol or drugs. Count three, testing positive for amphetamines. Count three, failure to provide verification of attending AA, NA twice a week. I'm sorry, 3 times per week until an outpatient. Count four, failure to provide verification of attending and completing outpatient treatment. Count five, by proof of completing community service by June 30, and count six, failure to clear all warrants by July 1 of 26. You understand each and every one of those charges?
Yes, sir.
On count two, the same 6 charges exist. Count two is the controlled substance charge. If you plead guilty, if you understand again all the charges.
Yes, sir.
If you plead guilty, if you're found guilty, your probation in this case could be revoked. You get more than 3 technical violations. You could get 93 days. And also, your drug charge, 7411 status could be revoked. And that conviction entered on your record by virtue of the violations here. You understand all of that?
Yes, sir.
You sign, read, and understand the advice of rights. You plead guilty, you'll be giving up all those rights, and we're not gonna have a trial at any time. You understand that? All right. You do have the right to a lawyer. I'll be happy to provide you with one at public expense if you would like one.
Yes, sir.
If you like a lawyer.
Yeah.
I'm entering a not guilty plea for you. Hang on 1 second. I'm indicating you stand mute, entering a not guilty plea on both of these. Did you have a question?
Well,
I don't want you to talk about the case. You just asked for a lawyer. I want you to talk to your lawyer about the case
Okay.
before you talk to me about the case. Do you want to say something or ask the question? I don't want to talk about the case.
it's just about money.
I don't want to talk about money.
Okay.
Okay? Your lawyer can address all of this with you, okay?
Okay.
Fair enough?
Yep.
Good enough. You go out in the hallway, I'll set you up with a lawyer.
All right. Thank you.
I'm entering a not guilty plea on this. Thank you.
good morning, Judge Bianca, TOPA 2378 on behalf of Mr. Gerald, station board member.
Drew Gerald Jr.
He's got 6 counts. We have 1 conviction for operating while visibly impaired. We have another charge, a drug charge that was taken under 7411. That was for cocaine. And he has 6 charges. I arraigned him on the charges. He indicated he wanted probation violation charges, I should say. He said he wanted a lawyer. I've appointed you. How we doing here?
So, Your Honor, he would like to plead guilty to the allegation with an explanation for each.
I can't wait to hear it. You understand everything I've told you so far, right, sir?
Yes, sir.
You understand that you would now have the opportunity, I'm just saying, with 6 violations. You could have your probation revoked, and you could be incarcerated on this for up to 93 days on the impaired, 7411 status revoked on the drug charge, and you could get 90 days on that. Do you understand that?
Yes, sir.
And knowing all that, you still wish to plead guilty.
Yes.
And you just sign, read, and understand an advice of rights form in this courthouse today.
Yes.
You understand? If you plead guilty, we're going to be giving up all of those rights. And we're not going to have a hearing or a trial of any kind. You understand that?
Yes, sir.
All right. Now, as to count one, to the charge, you failed to pay fines and costs as ordered on both files. I told you to pay $75 a week. Last payment made, it says on June 1 of 26. How do you plead to that?
Guilty.
Did you fail to pay your fines and costs as ordered?
Yes.
Count two, that you failed to comply with probation in that you failed the chemical test on May 27 of 26, testing positive for amphetamine through onsite. How do you plead to that?
Guilty.
Did you in fact test positive for amphetamines?
Yes, sir.
You didn't have any prescription for anything, correct?
No.
All right. Count three, that you failed to provide verification of attending AANA 3 times a week until an outpatient treatment. How do you plead to that?
Guilty.
Did you fail to attend AANA 3 times per week?
Yes, Your Honor.
Count four, that you failed to provide verification of attending and completing outpatient. How do you plead? Outpatient treatment with aftercare. How do you plead?
Guilty.
Did you fail to do that?
Yes, sir.
Count five, that you failed to provide proof of completing your 8 hours of community service by June the 30. How do you plead?
Guilty.
Failed to do that.
Yes, Your Honor.
Count six, that you failed to clear all warrants by July 1 of 26 is ordered. How do you plead?
Guilty.
You failed to do that.
Yes, Your Honor.
Anybody force you to plead guilty?
No.
All right, John, I'm going to need Madeline in here. I'll accept your plea for guilt to all those charges. I find they have been made voluntarily and understandingly and are accurate pleas, so the plea is accepted as follows. Count one, the failure to pay fines and costs is ordered. Count two, the failure to test negative, in other words, positive for amphetamines, had a chemical test on May 27. Count three, failure to attend AANA 3 times a week. Count four, failure to attend outpatient treatment. Count five, failure to attend community service. And count six, failure to clear all warrants by July 1. What's your name?
Madeline Rogers, probation, Your Honor.
You got your work cut out for you, Ms. Patillo. What's going on?
So, Your Honor, as it relates to the outpatient, Mr. Gerald had found work. He's been working at VidCon for about 3 weeks doing sheet metal for the local 80. The reason that he didn't do that is
Because he was looking for a place to do it virtually, which would go along with his work. He did find a place to go to, but they had copay, and at the time, he couldn't afford that.
When did he acquire his employment?
It was 3 weeks ago.
Yeah.
Was he going to AA the whole time?
No.
I thought I said to go to AA when I sent you on May 7th, 3 times a week until an outpatient.
You did.
And now you're saying you got work 3 weeks ago, which would put us at the latter part of June. And that's why you didn't go to outpatient, because you didn't have the time now. But yet you didn't go to AA 3 times a week, right? Am I missing something? I just want to make sure I understand. Is that true? Yes, right?
To an extent. I mean,
To an extent. Well, to what extent?
when I had the time, I didn't have any money. I mean, I
Does
could.
it cost money to go to AA?
Well, no, it cost money, but gas in my car.
Did I tell you? Give me a break. Did I tell you to call the court and go on Zoom with me if you didn't have the money to pay?
Yes, Your Honor.
Here's the tension in almost every one of these cases. He finally gets a job, which is good, but the job is also why he stopped going to AA. The court ordered treatment on a schedule, and life didn't cooperate with that schedule. It's a real conflict, but the judge's job isn't to solve his calendar. It's to enforce the order.
So
He
that,
had the money to use drugs. He's got a problem. Go ahead.
well, the positive, and I
Can't wait to hear
don't
that.
misspeak, it was an Adderall pill, that he had gotten from somebody at work. So it wasn't, he didn't purchase.
I see. So somebody else passed along an analog, contrary to law, and he took it and he ingested it.
Yeah, it was stupid. I made a bad decision.
As to the warrants, the same thing with the money, Judge. He didn't have the money. I know.
I can forgive the money. I don't forgive the fact that he didn't call, but I'm not even worried about the money. I'm worried about the fact that he's testing positive, isn't in treatment, didn't do his AA, didn't clear his warrants. He didn't do anything. Did he do anything?
No. So I would say it is my understanding that this is an 18-month probation. He was just put on probation May 7, 2026. I would ask if the court will refrain from revoking the probation or any jail time. While he was given dates to complete everything, he knows that it's only been about a month and a half. And it is a struggle when you don't have a job and when you get a job and you try to keep that job. So now he understands how serious this is. Your Honor could revoke probation, but I would ask if the court would allow him to continue on probation now that he has work and money. He should be able to take care of something.
Can I see the screen report? I don't just order AA nilly-willy. There was something in this report that told me I needed to do this. I obviously didn't do a very good job. You didn't think, you're not listening to me at all. You were using cocaine, getting behind the wheel. What do you think?
I mean, in terms of not having a job, I can understand. However, Mr. Gerald was driving to school daily. It was a pretty far drive from what I recall, because that's actually why we missed our first appointment, is he was driving on the freeway still. So it would be easy to stop at a meeting, on the way or on the way home. So I am very concerned because at this point, there have been no efforts made, nothing's been completed. And he hasn't communicated with me at all, and, issues or anything.
Just the school was actually for his work. I don't know if that makes it any better, but again, Judge, he was just put on probation May 7th. I would ask if the court would give him a little more time just to be compliant with at least some of this stuff.
If you'd done some of it, I could listen to that. You did nothing.
Did pay a decent amount of fines, I believe. I shouldn't be that far behind. I don't think, maybe 2 or 3 payments.
And he also brought $500 to me.
Yeah, I do have money now to.
Good, you can apply that to your bond, or to your fines and costs. I'm not gonna order any extra costs. You are, however, I'm gonna keep you on probation subject to all existing terms and conditions. You're to serve 6 days jail forthwith. You have 21 days to appeal, 14 days to apply to the lawyer for purposes of appeal. Hope this doesn't cost your job, but I didn't. You will. If you have completely ignored orders, you're on a short leash with me, sir. It could have been a lot worse. Have a seat in the jury box. Good luck.
6 days, not 93. That's the judge choosing restraint over the maximum she was entitled to impose. He failed on all 6 counts and she still kept him on probation instead of revoking it outright. That's not leniency because the violations didn't matter. It's leniency because he's 18 months into probation and just started paying attention.
Good morning, Your Honor. Joe Joseph for the plaintiff.
Sandra Cox. We do not have her. And you're turning on, there we go. If you'd like to take the default, raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Judge.
All right, go ahead.
Thank you, Judge. We are requesting an entry of a default judgment for possession only. This is a termination of tenancy matter that comes before your court after a failure to cure a health and hazard defect here, as stated in the notice to terminate. which was submitted along with our complaint. We're just asking the court to enter default judgment with the possession date of, or writ date of July 10th, or 20th, I'm sorry.
Judgment to the plaintiff, that is by default for possession, redemption amounting, there is no redemption amount, writ to issue in 10 days.
Thank you, Judge. Have a good weekend.
You do the same, sir.
Thank you.
Group 5 management versus Ika Kelly.
Present, Your Honor.
Good morning, Your Honor. Robert Wise appearing on behalf of Group 5.
All right. And what is plaintiff's claim in this case?
Plaintiff's claim, there's $1,492 owing, but we have not yet received the housing portion of 933. So currently, Ms. Kelly would owe $559, assuming the 933 payment is received soon.
Okay, the Section 8 type payment. Is that what you're indicating, Mr. Weiss?
Yes,
It's a housing assistance payment that hasn't been received as of yet, but her portion, you have at $559.
correct.
Is that inclusive of your court costs?
It is, Your Honor.
All right. Okay, Ms. Kelly,
Yes.
how are you intending on getting this resolved?
I'm seeking an adjournment because I haven't received my new portion from MISTA, and I also haven't received a ledger from Group 5 Management or Randolph Court Apartments. I submitted paperwork to housing, but they have not updated my new rental portion.
This case hinges on money that hasn't even arrived yet. She's on a housing assistance program, and until that subsidy payment comes through, nobody, not her, not the court, actually knows her final balance. That's a common wrinkle in Section 8 cases. The tenant's portion can't be locked in until the government's portion clears.
Got it. So you're waiting for the update of what you're going to owe each month.
Yes.
Gotcha. Okay. So you're entitled to an adjournment. I will adjourn it to 17th.
At 8:30?
Have we adjusted the dockets for Judge Brown's now?
Yes.
Okay. July 17th, 2026 at 12 noon.
Thank you.
All right. Thank you.
I do it by Zoom, Your Honor, or make a
Pardon?
request?
Mr. Weiss, you know how it works. Why do you ask me that each time? You want me to say no. No, yes, you can do it by Zoom, Mr. Weiss.
Thank you.
Thank you.
Have a nice weekend, Your Honor.
You do the same.
Have a great weekend.